on behalf of Judge Bennett and Judge McBrayer. We welcome counsel to our oral argument this morning, which is being live streamed for the benefit of the public. We will conduct the hearing in the same manner as if all of us were in the courtroom together. Each side gets 15 minutes and the appellant has already reserved some time for rebuttal. Unless there are any questions or announcements, I'll ask Mr. Hibner to call the case.
Rochelle Yvonne Lillard versus Robert Walter Lillard.
The floor is yours.
Thank you, Your Honors. My name is Jim Widrig, and I represent the ex-husband, the father in this matter, Robert Lillard. The parties were divorced by the Fourth Circuit of Davidson County on June 1st of 1999. 15 years later, on October 29th, 2015, the day before the child in this matter turned 18 years of age, the mother filed a petition to modify the child support and declare the child severely disabled. On May 9th, 2018, the parties entered into an agreed order which specifically found that Brooke, the minor child, or I guess child, not really minor anymore, but to be disabled as defined by the American Disabilities Act. The agreed order reserved the issue of whether or not the child was severely disabled. And the trial was conducted on July 2nd and 3rd before Judge Smith in the Fourth Circuit Davidson County Court. September 3rd, the trial court entered a memorandum and ordered the father to pay the child support the sum of $1,098.90 per month for Brooke's benefit. And the trial court found that Brooke was severely disabled within the meaning of 36.5.101(k)(2). Really, that's the issue that is the main issue in this matter, is that statute, 36.5.101(k). There's two sections of that code. That code is dealing with the extending of child support past the age of minority. K1 says, except as provided in K2, the court may continue child support beyond a minority for the benefit of the child who is handicapped or disabled as defined by the American Disabilities Act until the child reaches the age of 21. K2 goes on. K2 says, provided that such age limitations shall not apply if, 1, such child is severely disabled, 2, and living under the care and supervision of a parent, 3, the court determines that it is in the best interest to remain under the care and supervision, and 4, that the obligor is financially able to continue to pay child support. Statute that K2 goes on says, in such cases, the court may require the obligor to continue to pay child support for such period as it deems in the best interest of the child. Therefore, if the court goes through all those factors, then it needs to set a time period for this child support to continue. The code continues that says, provided, however, that if a severely disabled child living with a parent was disabled prior to the child attaining 18 years of age, and if the child remains severely disabled at the time of entry of the final decree of divorce or legal separation. Note back that the final decree of divorce was entered 15 years prior to this proceeding taking place. Also, secondary argument to our brief is that there is no time period set by the Fourth Circuit Court. Once they found that the child was severely disabled, they did not set a time period. The fact is that the minor child, I still say minor, but the child was dating, had a boyfriend, going out on dates. So the question is, if the child then moves out of the home, does the father still have this obligation to pay? If she gets married, does she still have this obligation to pay? Does this obligation continue forever? There is no time period set by the order. But the more important part is that we believe that there's no dispute that the child was disabled under the definition of the ADA, but that takes it again to the 21 years of age. In order to get past 21, you go to K2, and the child has to be severely disabled. So there's a heightened burden of disability needed. Hence the code, the word severely. And the K1 just says that the child is disabled as defined under the ADA. K2 requires a severe disability. So there is no definition of severe disability under the ADA guidelines. There's also no definition of severe disability under the Tennessee Code. The ADA guidelines defines what a disability is, and it says that disability is a physical or mental impairment that substantially limits one or more life activities. And then it lists what these life activities are: caring for itself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, thinking, communicating, working. Now, it goes on to say the term severely limits. That term shall be interpreted consistent with the findings and purposes of the ADA Amendments Act of 2008. We believe that the trial court in this matter did not hear any testimony regarding the severe limits under the ADA Amendments Act of 2008. Again, we have to have a severe disability. The Court of Appeals has addressed a couple cases dealing with this code section. I've referenced these in the brief. One of the cases was actually cited in the trial court's order. But the Tennessee Court of Appeals addressed a similar issue in the unreported case of Gregory versus Gregory. In the Gregory case, provided a summary regarding whether the child is severely disabled. And I'm quoting from the Gregory case: "There is no statutory definition of severely disabled. However, this court has addressed the issue in both Cook v. Hess and Finn v. Bundy. The determination of whether a person is severely disabled requires an individualized assessment of how that person's physical and mental impairments affect his or her ability to live independently. The Finn child had severe medical impairments. He was also, quoting, mentally retarded and had impairment of speech and fine motor skills, had a mental age between 5 and 8 years old. The child's physician submitted a report in the Finn matter that the child was unable to live without adult supervision, and that the parents in that matter testified they couldn't live on their own. The Cook child suffered from spina bifida and resulted in a physical and mental problems. The Cook child was also wheelchair bound. In the Gregory case, that child suffered from epilepsy, mental retardation, was found that the mental condition was in a decline at the time of the trial, had physical issues, and was unable to work. The Finn child had 14 surgeries before year 1 and had removal part of their cerebral tissue, and it impaired the muscular coordination. Again, you have to have a severe disability to get past the age of 21 threshold. The Cook child had over 25 surgeries in his lifetime, and again was wheelchair bound. But unlike the Preston, those other children, Brooke, in the matter of this matter, she graduated on time with her high school class. There was some testimony that she had some scoliosis, but she was a junior varsity and varsity cheerleader while in high school. She participated in dance and gymnastics. She was physically able to do work. She worked at Lowe's. She bagged groceries. She watered plants. She helped load groceries into customers' cars.
Well, but you're not suggesting only someone with only a mental impairment could be severely disabled, or are you?
No, you could be physically or mentally severely disabled. The proof in this matter was that.
So, well, what would constitute, what would pass the threshold in your mind if someone had no physical impairments, only mental impairments? What would be crossover from disabled to severely disabled?
That is actually the very interesting point of this case. The other previous cases dealt with physical and mental disabilities. This matter only dealt with, there's no testimony that she had any physical limitations. The only question in this matter is mental limitations. And the proof is that she was able to use the stove, make sandwiches on her own, she was working. So the question is going to be was the proof sufficient that she was severely disabled mentally, not physically? I don't think there's a dispute that she's not physically able to perform functions, walk, eat, all the listed things that were in the disabled category. So that's the question, is whether the burden of proof was established that she was mentally severely disabled. So
you don't have a suggestion of what that threshold might be for someone to be mentally impaired at the severely disabled level?
That's the part that I don't know, because again, I'm not a doctor to say that this person is or is not mentally, and I believe that would require a expert testimony.
But we do know IQ numbers here, for whatever that's worth.
Correct.
Should that be a factor in determining severe mental impairment?
I think that can be a factor, but you need somebody to interpret those numbers. Otherwise, we're looking at data that you can't just Google these numbers and see what they would fall onto. I think that would need to be presented at the trial court of what these IQ numbers mean, and without some sort of baseline understanding of how this affects, what does that number equate to? That's the problem, as I don't think there was any.
You're suggesting that wasn't present here in this case?
Correct. There was IQs that were done prior to the trial, and there was a conservator action taken prior to this trial. Those were by agreement of counsel submitted to the trial court in this matter, but there was no expert testimony from medical providers as to what the IQs are at the time of trial, or at what those IQs mean that she is severely disabled versus disabled.
All right. Thank you, Mr. Widrig. We'll hear from you further on rebuttal. Ms. Brown.
Good afternoon. I'm Ann Rawls Brown with Stites and Harbison on behalf of the mother, Miss Lillard, who we've been representing on a pro bono basis for a while now. And it is our position that the trial court did not err in finding the adult child, Brooke Lillard, to be severely disabled. Addressing the first issue with the court, when determining whether an adult child is severely disabled, an individual assessment must be conducted, and an essential requirement of that is the person's physical or mental impairments that affect his or her ability to live independently. In doing so, the trial court focused on whether there is a functional impairment of life activities of self-care, learning mobility, self-direction, capacity for independent living, and self-sufficiency. Father argues that no proof was presented at trial that Brooke is severely limited in any areas of her major life activities. To the contrary, the proof established that Brooke has a low IQ of 68, as well as a diagnosis of ADHD. And while there was not an expert that testified to this, the parties agreed and stipulated to submitting the evaluations by Dr. LaBarbera into evidence in lieu of him testifying in court, as well as a physician's report that was conducted for the purposes of the Davidson County 7th Circuit Court conservatorship hearing. And Brooke graduated high school, yes, with her class, but was in special education classes and also received a special treatment through the IEP program. The Davidson County Court of the 7th Circuit found that Brooke requires a conservator, and mother was appointed conservator of Brooke's person and property. The proof showed that Brooke requires assistance from her mother managing her daily routine, finances, and health care. In the unrebutted physician's report that was entered into evidence at trial, Brooke's physician recommended that Brooke needs a fiduciary for her physical well-being, to handle her finances, and to consent to medical treatment and relocation. The guardian ad litem report also stated that Brooke has a developmental delay and needed assistance with managing her daily routine. The proof established that.
Are these facts properly in the record in this case, or
Yes,
are
sir.
you? Okay, so you're not referring to the conservatorship evidence.
They were put into evidence in this case, Your Honor.
Thank you.
The proof established that Brooke is not capable of making rational financial decisions. The trial court found that Brooke cannot distinguish the difference between 5 cents and $5. Brooke's psychological evaluations conducted by Dr. LaBarbera showed her to be deficient and well below average in problem solving and mathematics. This has limited her ability to count money and do basic math functions, which have caused her to be fired from previous jobs. There were many similarities in this case to the facts in Cook v. Hess. Both Brooke and the adult child in Cook were appointed conservators to make all their financial decisions. Both required assistance from their parents to manage their checking accounts, were not allowed to work at the cash registers at their jobs, struggled with math. However, the adult child in Cook had an IQ of 91 in comparison to Brooke's IQ of 68. In Finn versus Bundy, the court found that an adult child to be severely disabled in part because he could not handle money and had no concept of the value of money. The proof further established that Brooke cannot perform everyday tasks that are essential to her physical or mental well-being. As set forth in a few cases where adult children were found severely disabled, in Tooley, the evidence showed that an adult child was severely disabled in part because he could not take care of his physical needs, his affairs, or personal hygiene. In Cook, the adult child had difficulty remembering to perform most essential tasks, such as personal hygiene and taking his medications. In Gregory, the court found that a child's failure to maintain personal hygiene is evidence of her being severely disabled. Here, the conservatorship vests almost all of Brooke's rights involving her daily decision-making powers with mother. Specifically, the trial court found that Brooke cannot be left alone. She has problems understanding time. She must be told to bathe. She has to be reminded to brush her teeth. She requires assistance with medication. She does not have a driver's license because she failed the driver's test and has to be transported everywhere. Lastly, Brooke cannot financially support herself. At trial, Brooke was working a part-time seasonal job at Lowe's at only approximately $11 to $12 an hour, where she was mainly responsible for watering plants. It took Brooke longer to perform tasks, and her manager testified at trial that Brooke has problems with forgetting things and does not remember instructions. Further, Brooke has never had or maintained a full-time job. After an individual assessment, the trial court found that by a preponderance of evidence that Brooke's mental and intellectual impairments prevented her from living independently. The second issue was that the trial court did not abuse its discretion in ordering child support to past the age of 21. As previously stated, Tennessee Code annotated 365-101K2, child support may continue past the age of 21 if the child is severely disabled, which the court found, and living under the care and supervision of the parent, and that the court determines that it is in the child's best interest to remain under the care and supervision, and that the obligor is financially able to continue to pay child support. Specifically, Mr. Lillard claims that the trial court did not find that Brooke was living under the care and supervision of the parent, and that it was in Brooke's best interest to continue to live under the care and supervision. However, at trial, it was undisputed that Brooke lived under the care and supervision of her mother. Both Miss Lillard and Brooke's unrebutted testimony established this fact. Further, the court found that Brooke could not be left alone. In father's own brief, he testifies that on a daily basis, mother makes sure Brooke gets up on time, takes a shower, washes her face, and coordinates her clothes. Mr. Lillard's arguments rest on a mere alleged oversight that would require this court to remand the decision and confirm a fact that was undisputed at trial. Accordingly, this court should invoke Rule 36A of the Tennessee Rules of Appellate Procedure to avoid further needless litigation on that issue. Moreover, the only proof established presented at trial showed that Brooke's interests are served best by continuing to live with mother, since the trial court found that Brooke is incapable of living independently. Brooke continuing to live under the care and supervision of her mother is almost certainly in her best interest based on the reasoning and facts previously mentioned. Remanding this case would again be a waste of time and resources. Accordingly, the court should invoke Rule 36A to avoid needless litigation on this issue. And in the alternative, an appellate court may choose to remedy the trial court's deficient factual findings by conducting a de novo review of the record to determine where the preponderance of evidence lies. The record will show that Brooke was living under the care and supervision of her mother, and that due to her impairments and inability to support herself, it is in her best interest to continue doing so. Lastly, father asserts that the 2008 addition to the statute required the trial court to find Brooke was severely disabled at the time the parties' final divorce decree in 1999. However, this reading of the statute is misguided, and the trial court was not required to do so. The Tennessee Court of Appeals interpreted the 2008 amendment in Woodard v. Woodard. The 2008 amendment only created additional authority for a court to order continued support, not an additional requirement that the child must be declared severely disabled before the time of divorce. Alternatively, even if the father's interpretation of the amendment is correct, it would not apply here because the parties were divorced prior to the amendment being passed. Statutes are to be applied prospectively unless the legislature clearly indicates to the contrary. Here, the legislature only provided the amendment would take effect on July 1st, 2008, so the amendment would only operate prospectively and not retroactively. The last issue was the trial court's method was appropriate to determine child support. The statute provides that the court may use the child support guidelines. Accordingly, it is in the court's discretion of whether to apply child support guidelines. A trial court only abuses its discretion when it applies an incorrect legal standard or reaches a decision that is against all logic and reasoning. Here, the trial court decided that the child support guidelines were not the best method to determine the amount that the father should pay. Instead, the trial court reviewed each party's income and expense statements, which both parties submitted after trial, and had the opportunity to cross-examine the other party on that, neither did. And the trial court considered mother's needs, Brooke, the adult child's earning ability, and father's ability to pay. Here, the parties stipulated to the income of each party, and the trial court determined that Brooke and mother lived a very frugal lifestyle and still imputed over half of Brooke's income to contribute to mother's costs of supporting Brooke. Based on the applicable law, the trial court was well within its power to calculate child support this way, and its decision should be affirmed on that matter. Further, to address the issue about the time period that child support was set, child support is always under the control of the court. Thus, if the child was ever able to live independently from her mother, father could petition the court to modify child support at that time. That would be the hope. However, based on the facts of trial, that doesn't seem the likely case. And mother and the trial court found that mother has done everything to try and attempt to have Brooke live independently, especially on her own, but it's just has not been able to do so. I'm happy to answer any questions that you may have.
You said the parties stipulated as to their income. Did they stipulate as to their living expenses?
No, Your Honor, they did not. That was submitted. The income and expense statements were submitted to the court, and the court found no issues with mother's income expense statement. They said that it was very frugal. There was several issues with father's expenses, such as 2 automobiles and no household, even though I believe he was the only one that was living in the house. And the trial court also noted that he had $1,000 a month in attorney's fees, which the court found was not a long-term debt. And previously, I'd like to just mention that in prior litigation, when the petition to reduce child support in 2013 was filed, father misrepresented his income to the court to be approximately $42,000, and the court ordered reducing his child support at that time. And then we, on behalf of mother, filed a motion to alter amend, and the parties ultimately entered into an agreed order providing that father's income was $69,000, and this was in 2013. But that's something just to consider for the court as well. But he also did not make any financial contributions to mother Brooke aside from child support since 2014, when he purchased a laptop and a DVD player for Brooke. And since she was about 12 years old, she'd been exclusively living with mother under her care.
All right. Any questions from the panel? All right, thank you, Ms. Brown. We'll hear a rebuttal from Mr. Woodrick.
Thank you.
Thank you, Your Honors. I'd like to point out the fact that after high school, Brooke went on to a college-type program. She received a certificate from the Tennessee Center for Applied Technology as a child care leader. At the time of trial, she hadn't even applied for any child care industry jobs. She was working at one child care agency, had a disagreement there, did get terminated from that job. But the brief of the mother's attorney said, quote, "There is no proof presented at trial that Brooke ever planned or attempted to live independently." And it gives the site reference to the trial court volume. That's kind of the issue here, is because, again, is she disabled or severely disabled if she's never attempted to live on her own and never planned to? The expert testimony of the conservatorship that was brought into this matter by agreement of the trial counsels, again, dealt with the fact that she needed help with handling finances. But again, that's a disability, not a severe disability. Again, using the Webster's definition of severe, there has to be a greater point than just the disability threshold under the ADA. Brooke has her own computer. She has her own cell phone. She records YouTube videos, puts them online herself. She has her own debit card. She has her own bank account. She uses her income to pay the water bill and phone bill for her and her mother, albeit that these are entry-level jobs that she has, but there's nothing wrong with those jobs and she can adequately perform them. So we do not believe that she was severely disabled under the guidelines.
Thank you both for your arguments, and we will take this matter under advisement. Mr. Hibner.